According to reports, Ripple's ideas extend back 4 to 5 years before Bitcoin. Canadian computer programmer Ryan Fugger created Ripple Pay in 2004-2005 to give online community members safe payment choices over a large worldwide network. However, it would be another 6 years before the founding fintech business, now known as Ripple, and the blockchain-based payment system known as XRP were launched. Let's find out the updates on the SEC case versus Ripple. Welcome to Crypto Inquiry, where we are dedicated to providing you, the investor, and the crypto curious with factual information and topics. Our goal is to keep you informed to make educated and timely decisions and remove the fog of hidden information. Nothing is meant as financial advice, and always do your own research before investing. Here we are building a community to help each other stay informed and make the most of our financial gains. What is Ripple and the XRP cryptocurrency? The U.S. Securities and Exchange Commission, or SEC, asserts that the asset is an unregistered security that Ripple marketed in violation of federal law, and the business is now engaged in a legal dispute over XRP. To address the inefficiencies of cross-border transfers and payments in conventional banking, researchers Arthur Brito, Jed McCaleb, and David Schwartz originally developed the XRP ledger in 2011. It is an open-source public blockchain. The three would subsequently form the business that is now known as Ripple, with Chris Larsen serving as the role of CEO. The decentralized XRP cryptocurrency works on Rails, called the XRP ledger. The Ripple Transaction Protocol, or RTXP, which is distinct from the XRP currency, was formally introduced in 2012. Shortly after, in 2013, the firm, which was formerly known as OpenCoin, changed its name to Ripple Labs. In 2015, that business once more changed its name to Ripple. Even while Ripple and XRP are inextricably linked, they remain distinct organizations, at least on paper. The decentralized XRP payment system was created by Ripple, a centralized fintech business that creates solutions for international payments. XRP, a standalone digital asset with a market worth of around $83 billion as of March 2022, is utilized for activities like online payments and currency swaps. SEC Ripple call for immediate ruling whether XRP sales violated securities laws. Both the SEC and Ripple Labs are requesting that a federal court declare either that the cryptocurrency business connected to the XRP coin breached federal security laws, or else dismiss the case without a drawn-out trial. In the Southern District of New York, the SEC and Ripple both submitted applications for summary judgment, requesting that District Judge Annalisa Torres rule based on the arguments presented in supporting papers. The records were published on a federal court's database. In December 2020, one day before former SEC Chair Jay Clayton announced his resignation, the SEC filed a lawsuit against Ripple Labs, CEO Brad Garlinghouse, and Chairman Chris Larsen over claims that the company had raised more than $1.3 billion by selling XRP in unregistered securities transactions. According to Ripple, XRP sales and trading did not adhere to the Howey Test principles. Over the past 2 years, the parties have filed several discovery motions, but they haven't litigated the core dispute at hand, which is whether Ripple sold XRP in violation of the Securities Act. The petitions for summary judgment signify the parties' request for the court to determine whether the SEC or Ripple has produced sufficient evidence to conclusively establish whether there was a violation or not. The SEC contended, among other things, that several remarks made by officials of Ripple show that Ripple sold XRP and that XRP investors purchased the cryptocurrency in the hope that it would appreciate over time. According to the SEC's lawsuit, Ripple publicly talked about the many measures it has taken and would take to find a use for XRP and to safeguard the fairness and liquidity of the XRP markets. For its side, Ripple contended that the corporation had no contract with XRP investors and that there was no shared enterprise which was necessary as per Howey. According to the company's filing, many XRP holders who bought tokens on exchanges wouldn't have understood who they were buying them from. Even if the SEC were to engage in a belated post-discovery transaction-by-transaction analysis to identify XRP offers and sales with contracts, its claim would still fail as a matter of law. Not one of those contracts granted post-sale rights to recipients as against Ripple or imposed post-sale obligations on Ripple to act for the benefit of those recipients, the filing said. XRP jumps 20% amid SEC's setback in Ripple lawsuit. XRP, the sixth largest cryptocurrency asset by market capitalization, is surging as a result of Ripple Labs winning a legal battle against the SEC. A court order requiring the SEC to provide papers that Ripple plans to use as proof caused an increase in the price of almost 20% for XRP. The SEC's opposition to publishing a speech of interest by William Hinman, its former director of corporate finance, was rejected in the decision. According to Hinman's 2018 lecture, Ethereum is not a security. In late 2020, the SEC filed a lawsuit against Ripple, alleging that the payments company offered XRP as an unregistered security. In light of the judgment rendered by District Judge Annalisa Torres, legal expert James K. Fillon now asserts that the SEC may use several tactics to postpone compliance. The SEC has a number of procedural cards they can play to try to further delay complying with the order to produce the Hinman documents. They can first petition Judge Torres to rescind her decision to override the SEC objection. Second, they might ask her to certify an appeal of the ruling she gave rather than pursuing the petition for reconsideration. Third, they might submit a petition for a writ of mandamus directly to the Court of Appeals. These are all low-probability tactics. However, if the SEC wants to postpone turning over the information, they may use any or even all of these strategies, and it might take another 2 to 3 months to sort things out. Ripple partner releases sensational appeal to court and SEC. iRemit, a cross-border remittance company with headquarters in the Philippines and a significant partner of Ripple, has submitted a brief in favor of the cryptocurrency business and XRP in a legal action brought by the SEC. The business has requested that its request be taken into consideration by the court, in addition to making a formal declaration about the circumstance. iRemit's memo came out as overbearing. In it, the business explains why XRP is not a security and contends that making such a claim is the product of a lack of knowledge of contemporary digital technologies. iRemit also confronts the SEC directly, claiming that their activities appear to be an attempt to misrepresent key elements and tenets of cryptocurrencies and blockchain technology and to impose regulatory action in areas unrelated to their core business. In addition, the business, which recently declared a partnership with Ripple, stated that as a frequent user of XRP, it never viewed the cryptocurrency as an investment, but rather as a tool for quick, effective cross-border transactions. iRemit justifies its unexpected statement by stating that it has a keen interest in the result of the procedure. The Philippines-based business, which was founded in 2001, has been one of Ripple's on-demand liquidity corridors in Asia since 2018. When iRemit was granted permission to use ODL for treasury payments, the two businesses recently strengthened their alliance. The announcement was well received, and Yoshitaka Kitao, the current CEO of SBI Holding and a previous member of the Ripple board, even shared it on social media. Private jet charter company wants to highlight XRP's utility. TapJets, a provider of private jet charter services, has requested the court to allow it to submit an amicus brief in support of blockchain startup Ripple in its legal dispute with the SEC. The purpose of the brief is to clarify the token's usefulness, which the SEC has identified as an unregistered security. Such a payment option, according to TapJets, which takes XRP in exchange for its services, is vital since it enables travelers to book flights outside of regular banking hours without having to worry about wire transfer transaction caps. As a result, the business may offer its services in real time. TapJet's assets in its letter move that it has no business ties to the case's defendants. The business does, however, claim that because it has invested in the technology, it has a stake in the litigation's result. According to TapJets, if the court finds XRP to be a security, it will harm the company's bottom line and probably restrict it from utilizing the token. The only business that enables fast private jet charter bookings is TapJets. The organization must continue using the XRP cryptocurrency since the immediate usage of its services is essential to its business model. That's a wrap for this video. Let us know in the comments below if you think Ripple is in the right or if it is the SEC. If you enjoyed this video, give this a big thumbs up. And don't forget to subscribe to our channel if you want to see more videos like these. See you next time.